Tender of pardon to an accomplice. The administration of criminal justice often becomes difficult in cases involving organized crime, conspiracy, corruption, terrorism, and other serious offenses. Where direct evidence is not readily available, in such cases, the prosecution may require the assistance of a person who participated in the commission of the offense. To secure such evidence, the law permits the grant of a pardon to an accomplice on certain conditions. The term pardon means the remission or forgiveness of punishment for an offense. In criminal law, a pardon is tendered to a person who is directly or indirectly concerned in a privy to the commission of an offense on the condition that he makes a full and true disclosure of all facts within his knowledge relating to the offense and the persons involved in its commission. A person accepting such pardon becomes an approver and is examined as a witness for the prosecution. Legal provision. The provisions relating to the tender of pardon to an accomplice are contained in section 343 of the BNSS 2023 corresponding to section 306 of CRPC, section 345 of the BNSS corresponding to section 308 of CRPC. Object of tendering pardon. The primary objective of granting pardon are to obtain evidence that may otherwise be unavailable, to facilitate detection of serious crimes, to identify principal offenders, to break criminal conspiracies, to assist the prosecution in securing convictions. The law recognizes that in certain cases the testimony of an accomplice may be indispensable for discovering the truth. Meaning of accomplice. An accomplice is a person who has participated in the commission of an offense either as a principal offender, an arbiter, a conspirator, or a person having knowledge of the offense. Such a person may be granted pardon if his evidence is considered necessary for the successful prosecution of other offenders. Power to tender pardon. Authorities competent to grant pardon under Section 343 1 of the BNSS 2023. The following authorities may tender pardon: the Chief Judicial Magistrate, a Metropolitan Magistrate, a judicial magistrate of the first class during inquiry or trial. The power may be exercised at different stages depending upon the authority concerned. Stage at which pardon may be granted. Chief Judicial Magistrate and Metropolitan Magistrate. These magistrates may tender pardon at any stage of investigation, inquiry, or trial. Judicial Magistrate of the first class. A judicial magistrate of the first class may tender pardon during inquiry or trial. Condition for grant of pardon. The pardon is not unconditional. The accomplice must make a full and true disclosure of the whole of the circumstances within his knowledge relating to the offense and every other person concerned, whether as principal or abettor in the commission thereof. Failure to comply with this condition may result in withdrawal of the pardon and prosecution of the approver. Offenses to which Section 343 applies. According to Section 343 2 of the BNSS 2023, the provision applies to offenses triable exclusively by the Court of Session or a special court. These include serious offenses that can only be tried by a court of session or a special judge established under special laws. Offenses punishable with imprisonment up to 7 years or more. The provision also applies to offenses punishable with imprisonment exceeding to 7 years or with a more severe sentence. Thus, the section primarily deals with grave and serious offenses. Duties of the magistrate. Under Section 343 3 of the BNSS 2023, the magistrate granting pardon must record reasons for granting pardon. The magistrate must state the reasons that justify the tender of pardon, acceptance or rejection, The magistrate must record whether the person accepted or refused the tender of pardon. A copy of this record must be supplied free of cost to the accused if demanded. Consequences of acceptance of pardon. When the accomplice accepts the pardon, examination as witness under section 343 4A of the BNSS 2023, he must be examined as a witness before the magistrate taking cognizance and during the subsequent trial. Custody until completion of trial. Under Section 343 4B of the BNSS 2023, the approver shall remain in custody until the conclusion of the trial unless already released on bail. This requirement prevents tampering with evidence and ensures the availability of the approver during trial. Procedure after examination of the approver. Under Section 343 5 of BNSS 2023, after examining the approver, the magistrate shall proceed without conducting any further inquiry. Cases triable by court of session. The magistrate shall commit the case to the court of session where the offence is exclusively triable by that court. Cases triable by a special judge. Where the offence is triable by a special judge, the case shall be committed accordingly. Other cases. In other situations, the case may be transferred to the Chief Judicial Magistrate for trial. Withdrawal of pardon. Under Section 345 of the BNSS 2023, if the public prosecutor certifies that the approver has concealed material facts, given false evidence, or failed to comply with the condition of pardon, the approver may be tried for the original offense and the offense of giving false evidence. Thus, the benefit of pardon is conditional upon complete honesty and cooperation. Case law. Saravan Abhavan versus State of Madras, 1966. The Supreme Court held that the object of granting pardon is to obtain evidence from a participant in the crime so as to secure conviction of the principal offenders. Lieutenant Commander Pascal Fernandez versus State of Maharashtra, 1968. The Supreme Court observed that the power to tender pardon should be exercised where the prosecution considers the evidence of the accomplice necessary for the successful prosecution of the case. State Delhi Administration versus Jagjit Singh, 1989. The Supreme Court emphasized that the approver must make a full and truthful disclosure of all relevant facts to retain the benefit of pardon. Importance or significance. The provision relating to pardon serves an important role in criminal investigations and prosecutions because it helps uncover complex criminal conspiracies. It facilitates prosecution of principal offenders. It enables the court to discover the truth. It strengthens criminal investigations. It assists in combating organized and serious crimes. Without such a provision, many offenses involving multiple offenders might remain undetected or unproved. Conclusion. The tender of pardon to an accomplice, section 343 of the BNSS 2023, is an important mechanism for securing evidence in serious criminal cases. It allows a participant in the offense to receive conditional immunity from punishment in exchange for a full and truthful disclosure of all relevant facts. By helping the prosecution secure crucial evidence against principal offenders, the provision significantly contributes to the effective administration of criminal justice.